right at the top of the hour. I wanted to thank everyone for joining us. This is our second installment of Trust at University. This is an educational seminar put on by ITM and the Life Insurance Trust Company. Today's session will be on the advantages of South Dakota trust law. Our presenters today, I will be hosting. I'm president of the Life Insurance Trust Company, and joining me here today is Jordan Veurink. Jordan is a partner at the Woods Fuller Law Firm. Jordan assists with all aspects of estate and tax planning. Families from around the world seek out Jordan's help to take advantages of South Dakota's trust laws and assistance in navigating South Dakota trust requirements. A couple of announcements we'll have before we get started on the presentation today. There will be a short survey at the end. We ask that you complete that. It allows us to give us some good feedback so we can continually improve and also respond to the needs of our audience here. Within 24 hours, you will receive an email with a link to the live recorded event, and also a link to request a certificate of completion and a PDF of the presentation materials. This link and that certificate of completion can be used to apply for continuing education credit. This has been approved by the American Bankers Association for 1.25 hours. On the agenda today, we'll talk a little bit regarding South Dakota on some of the tax efficiencies that our state offers, asset protection, privacy statutes we have, flexibility and trust design, trust modifications, some other miscellaneous advantages of South Dakota, some case studies, and then we'll open it up for some questions and answers at the end. There is a chat button there for anybody that has questions. Please type them into the chat. We will answer those at the end of the presentation. So with that, I'll turn it over to Jordan to give a little bit of the overview of the tax efficiencies and tax advantages that South Dakota has to offer.
Thanks for the introduction, Tony. It's great to be here today and to join you all for the presentation. As Tony mentioned, there's a bunch of different advantages of South Dakota that we promote to clients and to advisors. So these what we're trying to hit today is a high-level bunch. We talked a little bit earlier and kind of decided it was hard to pick out everything, but we tried to kind of hit, I think it's about 5 or 6 high-level advantages. The first one we wanted to start with was the tax efficiency. So like many states that are trust havens, I guess I'll call them, we have no state income tax. So the income generated by your trust in South Dakota will not be taxed by the state of South Dakota. Next one listed there is the low premium tax rate. So I don't know, this one seems to catches people off guard a little bit more just because I don't think it's as commonly used as, or at least promoted as some others, but especially in the context of PPLI policies and owning those in trusts or in South Dakota or in LLCs in South Dakota owned by trusts, whether in South Dakota or elsewhere, as long as they're managed in South Dakota, can qualify for South Dakota's 8 basis points premium tax rate on those policies, which is highly competitive. In fact, I believe it's still the best. I haven't checked lately, but it's certainly at the top with the top other states. The other one listed there is no state, estate, gift, or inheritance taxes. So I know some states that maybe some of you all live in have a state tax, have a state gift tax, inheritance tax, or some combination of those things. South Dakota has none of those and doesn't apply any of those to trusts.
Well, thank you, Jordan. I know, certainly specializing in life insurance, we've certainly taken advantage of that low premium tax at Life Insurance Trust Company. And I know one thing that comes up a lot is asset protection and people worried about, creditors getting their assets. What are some statutes that we have in South Dakota that are really unique to our state that allow for that asset protection?
Sure. Thanks, Tony. So I'll focus in just a few slides on this. The first one that we'll focus on is these first-party asset protection trusts. So I'm sure people have heard of these. We call them DAPTs, usually DAPTs, or first party or self-settled spendthrift trusts. A variety of names. They all essentially try to quantify the same thing, and that is a trust generally where the grantor sets it up in a state that allows for asset protection trusts, such as South Dakota, Delaware, Nevada, some good jurisdiction for that. The trust is irrevocable, has a spendthrift provision, so creditors can't foreclose on interest. So we can talk a little more about that in a minute here. Then the grantor retains a beneficial interest, and the goal of doing that is to kind of have your cake and eat it too. You put these assets into this trust, and ideally you don't touch them, but if a rainy day does come along, you're able to kind of come back in and take distributions of those assets if it's necessary. And when I say necessary, it's not quite what it is. Usually we set those up as discretionary trusts, where the trustee, who's preferably a South Dakota-based trust company or some other independent fiduciary, has the control to make or withhold distributions, generally in its sole and absolute discretion. State statutes don't always require that, but that's usually the best standard in terms of trying to protect from creditors and not try to create any kind of a health, education, maintenance, and support standard or otherwise create any kind of a mandatory interest, but make it purely discretionary. You can see there on the slide, I'm not much of a slide reader, so I'm hoping you can read that as we go along or read it afterward. I'll try to kind of stay on track a little bit. But South Dakota's got a great 2-year creditor look-back period. And essentially what the creditor has to show is that you, in setting up the trust and funding it, intended to defraud that specific creditor, which is a high standard compared to some states especially. I know Nevada's got a pretty good one as well, but South Dakota's right up there in terms of both the look-back period for transfers to asset protection trusts, as well as the standard for undoing those. One thing I was going to mention before we move on to the next slide, Tony, just because we're seeing it a little bit more now, is something called a hybrid asset protection trust, and it's worth at least mentioning today, mostly because what I talked about just now was where I would set up a trust for my own benefit, and in that case, a creditor comes along and I'd have to go through a debtor's exam if some judgment was obtained against me and disclose that I was a beneficiary of the trust I set up. In a hybrid trust, we sometimes give a trust protector, we'll talk about that later, or some other independent trustee, but oftentimes in South Dakota, an independent trust protector, the power to add and remove beneficiaries, which would include a class, and in that class would be the grantor. So I would set the trust up for my, say, spouse and children, and give a trust protector the power to add me back in as a beneficiary if in the future it made sense to do that. If I never need it, great. If I need it, I can be added back in as a beneficiary. We start to see that a little bit more just for the optics for certain, but also if you have to go through that exam and list out the beneficiaries, you wouldn't have to disclose yourself as being one if you hadn't been added.
Yeah, great statute there, and certainly like the hybrid aspect that you talked about there, Jordan. A lot of benefits there in having that trust protector and a lot of flexibility also that these offer. I know very few states allow these self-settled spendthrift trusts. What are some advantages of third-party trusts? So I set up a trust for my kids or grandchildren, not necessarily for the benefit of myself. But what are some advantages they have there?
Sure, certainly, Tony. So like I mentioned before, we're talking about first party. These would be called third party trust. And before, you can see in the slide there, it's the second point. The first one we put really in every trust is a spendthrift provision. I don't know, it'd probably malpractice not to at this point. But essentially, by doing that, South Dakota law gives you a very high protective standard for creditors to be able to foreclose, otherwise, sit in the seat of beneficiaries as far as getting at trust assets. It also generally prohibits beneficiaries from trying to pledge their interest in trusts or otherwise, grant outside creditors a security interest in trust assets. Those are generally prohibited by a properly drafted spendthrift provision. Moving on to the point Tony was making, and I appreciate that, Tony, didn't mean to jump the gun, but didn't want to skip the spendthrift piece, was third-party trust. So this would be a trust where Tony sets it up for my benefit. Thank you, sir. And in that case, we look not so much to the the look back periods or any of that. Tony still would have to not make a fraudulent transfer to the trust, but then we're looking at, for purposes of me, what can my creditors do as a beneficiary to come after that trust? And generally speaking, you can read the language there and the provisions of the law, but generally we're trying to make these trusts discretionary. And what that means is when I have a discretionary interest, creditors have a very, very difficult time coming into the trust to compel distributions to come out of them, or to otherwise second guess a trustee's decision whether to make or withhold distributions. You'll see South Dakota law there also provides that those interests, especially, and the others, you can see in there we talk about mandatory and support clauses, but focusing really on discretionary because it's what we see, is not a property interest. So in that, I can't, again, going back to the spendthrift provision, I can't pledge it, I can't assign it, I can't sell it. All they are is a mere expectancy. So if and when the trustee decides to make a distribution, then that hits my bank account, it's out, and creditors can do with it as they please. But until that time, it's very difficult for those creditors to reach into the trust and otherwise force distributions out of there. It's also very difficult for courts or creditors to reach into or to go to the courts and challenge that, just because the standard is so high. I think you'll see, I do have it there in the third point, only if the trustee acts dishonestly or an improper motive or fails under a duty to do so to act is the only way the trustee can be held responsible or otherwise be compelled to make distributions out of the assets, out of the trust of the assets, with respect to a discretionary interest. And the other two, I'll hit them quickly, mandatory and support interests. So generally support interest would require a trustee to make distributions, for example, for health, education, maintenance, and support. It's kind of what you'd expect, right? So in that case, the trustee would have a duty to make distributions for that. Protections for those are actually quite good too. And we'll go into the details of all that because we only have about an hour or so today. And the mandatory interest would be upon a beneficiary hitting the age of 30 years, the trustee must distribute 20% of the assets or something like that. And those are the interests, but none of those are actually deemed to be property interest in trust. And unless and until distributed, are protected from creditors.
Well, thank you, Jordan. Yeah, certainly a lot of protection for these third parties, and the discretionary interest and non-mandatory distribution seems to really be key in these. This is all fine and well. I know there's been a couple cases in South Dakota where this has been challenged and actually very successful in the validity of these trusts. Can you talk about a couple of those cases?
Sure. So it's always been kind of the tough spot in South Dakota. We'll talk about it later. Cases aren't reported generally. So we're only lucky enough to get any kind of guidance when a Supreme Court case, or a case appealed to the Supreme Court from a district court. It's only 2 levels in South Dakota. But when it gets appealed to the Supreme Court, we finally get a little bit of guidance. And one of the strongest cases in my mind is one from 5 or 6 years ago, the Cleopatra Cameron Gift Trust case. And very interesting case. I think some people wondered how it came to this result or why it came to this result, but let's kind of walk through the facts. So Cleopatra's father had set up a trust in California, had a California trustee, California choice of law provision. I think Cleopatra lived in California. In fact, I know she lived in California. And anyway, trust was set up. It was irrevocable at that point for her benefit. And she and her husband were going through a divorce. And in that divorce, the trust was pulled in, made a party to the divorce, and pursuant to a provision of California law, was ordered to essentially make payments to fulfill her child and spousal support obligations due to a provision of California law. And as time went, of course, I'm sure she got sick of it and decided, why am I dealing with this? Why is my trust paying this guy off for all these years and paying all this money to these kids? So the trust was moved to South Dakota. I believe it was in 2012 or so. I'd have to look back at the case to confirm, but it was right in that area. And at that time, again, getting sick of making those payments, or the trustee make those payments, my understanding is she made a request to the trustee to stop paying pursuant to the order in the divorce matter in California. Generally speaking, it seems like, I don't know, taking a step back and kind of analyzing it, I don't know how you'd assume that a trust or trustee could stop making payments if it's ordered to in a court to make those payments. But in this case, she ended up going, and I simplified the facts a bit in that first one about, the ex-spouse suing. What I understand actually happened was she asked the court in South Dakota to declare certain things. And in that petition, she asked the court to declare that was merely an enforcement action made pursuant to the laws of the state of California, not a judgment, but an action to enforce a judgment. And the court agreed with her and said that's all this is. This is an action to this is an enforcement action essentially. The ex-spouse didn't get his payments. He's the one who actually then appealed up to the South Dakota Supreme Court. And you can read the slide there if you'd like, but basically the Supreme Court agreed and said, look, this is an enforcement action under a specific provision of South Dakota or California law at that time, excuse me. And those California laws don't exist the same way as they exist in South Dakota. So if you want to enforce a judgment in California based on those laws, fine, if the trust is there. Now that the trust is in South Dakota, our laws say different things. Our enforcement obligations are different. You, in fact, cannot come to a state like South Dakota and enforce an order for child support as to a third-party trust and a beneficiary of that trust, and get the trust make the trust obligated to make the payments. So in the end, it made a lot of sense in terms of the reasoning behind it. But I think what a lot of people saw it as is, well, if I have a judgment against me or my trust, why don't I just get it to South Dakota and then I'll just stop making payments to whoever it is the trust or I owe. And there was a little bit of that, but really the facts were kind of narrowly focused to this enforcement action. But in the end, the trust was able to stop making payments to the ex-husband.
Certainly shows the support of the legislature and the court system in South Dakota and the power of these trusts for many creditors, including ex-spouses. So thank you, Jordan. I know one thing that comes up a lot from our clients and prospects is really the issue of privacy. Can you talk a little bit, Jordan, about some of the privacy statutes South Dakota offers?
Sure, glad to, Tony. So I think privacy is one of the things people sort of love most about South Dakota. There's a lot of things you can do that we've talked about in different states, and I've kind of mentioned it along the way that, standing alone, or there's a lot of things you can do in South Dakota you can do in other states, but all of these things you can usually do. But South Dakota is uniquely situated in terms of privacy. I think the biggest one's the one on the slide right in the middle there, silent trusts. So essentially, the law here is that you don't, well, I should take a step back. The law requires certain disclosures about trusts to be made upon the occurrence of certain events. But almost every practitioner here waives the requirements of that statute, which the statute allows you to do. And essentially, what you can further do is say a trustee is not required to notify any interested person, usually beneficiaries is who we're talking about, ever about the trust until they hit a certain age, until they've hit a certain milestone in life, or whenever you otherwise decide to notify beneficiaries about the existence of a trust. I always caution people a little bit. This is more of a practical tip than anything else. I don't think your beneficiary, son, daughter, whoever, I don't know if it's necessarily a good thing to wait until they're 60 years old to find out about this and then find out about it through some inadvertent disclosure by a trustee or some kind of maybe it's a first tax return that gets filed after the trust switches from a grantor trust to a non-grantor trust. So my counsel to people is normally certainly use those. It makes a lot of sense. Waive statutory requirements of giving notice. But if we're talking about silent, just think about how it makes sense to bring someone in. And if you're going to truly make it silent, maybe you think about, okay, what am I going to do outside this trust to bring them into family meetings? To otherwise, start to bring kids and grandkids and whoever it might be into family affairs. I don't, generally speaking, in my experience, the surprise of figuring out you have a trust, especially with the larger ones, can be kind of a game changer and a bit of I wouldn't say problematic, but certainly it changes the situation among families. And I think it might actually, in some cases, cause them to not trust parents. If they don't trust you to know about the trust, how can you trust them about anything else? So something else, I think what kind of has mitigated this, and one problem that I guess mitigation was designed to solve was, if you have a trust that, let's say the family wants to, bring to court, let's just say, and you have a current beneficiary who's 25 years old but not entitled to information about the trust, how is the trustee supposed to go to court and get accounts approved if that's what they want to do, or otherwise use a non-judicial modification agreement to change the trust? And so something that kind of sprung from this, I think, was the use of a representative, which is the bottom right one there. This slide doesn't provide a lot of information, but I didn't put a lot in here because it's more fun just to talk about it. But so essentially, South Dakota law also allows representatives to be appointed. So what you can do, and maybe other states allow this too, but South Dakota has a great statute on it, is to allow someone to receive information, to bind that person, to receive notices, consent on behalf of, essentially broadly represent the interests of beneficiaries. So in that case, you can have a silent trust as to people, let's say up to 30 years old, and if they're 28 and you want to get, an accounting approved by a court, the representative can actually receive notice of that on behalf of the beneficiary and act on their behalf. We use representatives pretty frequently anymore, at least as to underage beneficiaries. We also use it a little bit more in just trying to think about situations. And one that we've seen, unfortunately, was where a child of the grantor had passed away leaving kids, and only the children's mother, who was not of the bloodline of the settlors, was entitled to then represent them by law without appointment of a representative. So we're always kind of thinking about, do you want your grandchildren's mother to represent the kids' interests if they're not of age? Just one example of many that we kind of see, that we think about in terms of how we use that in trusts anymore. Kind of going from there, that bottom left has a virtual representation. I'm going to say, Tony, you can correct me if I'm wrong on this, maybe about 3 to 5 years ago, the statutes changed as far as who needs to get notice of trust matters. And usually we're talking about trust proceedings in court, but also can relate to who gets accountings and who has to sign non-judicial modification agreements and consent and things like that. The statute got very strong as far as who needs to first receive notice of things. So, for example, anyone who might take in the absence of the exercise of a general power of appointment wouldn't have to be given notice of a matter. But it sets out a list in South Dakota Codified Laws 55-18. It's a whole chapter. That's great, terrible reading material for anybody on the call, but fantastic for us practicing in it, because it allows us a whole lot of flexibility and a whole lot of guidelines and rules, frankly, for how we go about giving notice. So top left is no trust registration. I think this is getting kind of archaic now, people registering trusts with any court or the state or anything. But it's worth noting that you don't have to go and register a court. No one has to find out about the fact that you created this trust in terms of state or any government entity in South Dakota. I get the question periodically, do we have to do that or what's next? But of course, that's not required here. The last one is the court files being sealed. And I mentioned it earlier as to why we don't really have good case law. I guess that's the other side of it. Otherwise, we absolutely love it. When I go and I file, we filed a petition this week, I think, on about 15 different trusts. And those files are all sealed. So if you were to call and ask about it, they're not going to give you information about the trust unless you can show that you are an interested party in that matter. The clerks are very good about that. We've kind of informally, and not meaning to even, tested that, and it's very, very, very well sealed and very, very private for all trust matters automatically.
Well, certainly. Thank you, Jordan. Certainly a lot of great privacy. And as you mentioned, clients certainly like that. Could you speak a little bit about the flexibility and trust design, and, how we can work with grantors, advisors, and make special distributions and a little bit more flexibility in the trust?
So generally, I think, and probably 20, 30 years ago, maybe more like 20, directed trusts were extremely unique. They're certainly becoming a little more common now, but generally speaking, most clients who are coming to South Dakota, especially from out of state, are looking at using a directed trust. And what I like about South Dakota is it's been tried and tweaked and changed and edited many, many times over the past decades, I guess I'll just say, because I don't know exactly how long it's been. But in doing that, it's gotten very, very safe for trustees, which they appreciate. It allows them to kind of mitigate their liability because they don't have a lot of responsibility. And for those of you that don't know, I assume most people on this call have at least heard of a directed trust, but essentially, historically, you'd have a trustee that had all powers. You'd administer trusts, you would file tax returns, you'd invest, you'd distribute. Whatever had to be done with respect to that trust, the trustee was on the hook for. Which was nice centralized power, but what happened, again, in recent years, and maybe even before that, before it was even invented probably, was people would want to have the trustee be a certain group that knew how to administer trusts, but wanted to have assets in the trust that didn't necessarily make a lot of sense for a trustee to administer. For example, if you have a closely held business and you want to put it in a trust, if you find a big corporate trustee, they're not typically going to want to do that. I don't mean to speak for Litco, but most trustees don't want to run your closely held business. You've built that up. Your clients have built that up. They know what they're doing, and trustees just, typically wouldn't. So in light of that, the role kind of got chopped up a little bit, so to speak, into a trustee. And I don't have any kind of a section there to reference there just because it's all over the code, but it's almost more of an administrator, not a custodian. It's more than that, but certainly a role that allows the trustee to simply administer the trust, file tax returns, keep books and records in South Dakota, and generally take direction from others as to what to do as far as the investments and distributions. Which again, kind of simplifies the role, eliminates some liability, but by having that administrative trustee, at least in South Dakota, performing administration here, you've allowed yourself to avail yourself to the laws in the state of South Dakota. You can see the next roles there, investment advisor and distribution advisor. We can go into a little more detail on both those. I think we could probably spend a day on this slide alone, so I'm trying to kind of cover as much as we can in a little bit of time. But the investment advisor is typically going to be someone who controls the investments, and who that is kind of varies trust to trust, case to case. I'll just point out a couple of other details we don't have listed there. If we're talking about a closely held business like my example gave, we typically use the grantor. So let's just, I'll do a case study later, but for a quick case study, let's say somebody wants to use their lifetime exemption and put it into a trust with the partnership interest or LLC interest in their company. A lot of times they would make that gift to the trust, appoint Litco or another South Dakota trust company as trustee, and then either appoint themselves or somebody else. There's certain tax rules that they can't retain control of certain shares of corporations, so that's a different discussion for their day. But let's say they name a trusted employee as the investment advisor. That investment advisor then direct the trustee how to vote the interest of the shares, how to, is a sale, if the trustee needs to sign some kind of an obligation, some line of credit or something like that. Anything that relates to the investment or the ownership of those shares other than distributions from the trust would be held in the hands of that investment advisor. I know some people who are financial planners have served in that role. There's certain, I wouldn't call it a minefield of things to look for, but there are certain regulations that you need to be aware of if you're going to serve in that role as a professional fiduciary, like an investment advisor, just with an organization. So be aware of that. Generally, you can do that under South Dakota law because it's akin to your business, so it's not necessarily conducting trust business because that's what you do. But be aware of certain, again, I would just call it rules and other limitations on what otherwise regulated people and regulated companies and their employees can do with respect to serving as fiduciaries in South Dakota trusts. So distribution advisors, kind of the same thing. Going back to my example, if business owner puts a bunch of shares of business in, he normally want to name or normally could name somebody else who's not the South Dakota-based trust company to control distributions. Maybe it's a spouse, maybe it's a friend or somebody else. It doesn't particularly matter. There are tax things again to kind of be aware of there. So if I make a gift to a trust for Tony and I put my closely held business interest in there, I wouldn't want to retain that right to control distributions because doing so could cause inclusion of those assets in my estate because I've maintained the control over who gets distributed income and principal from the trust. The third one I've listed there is a trust protector, which is a little bit more unique too, and probably, I guess, a little more cutting edge than some of the other ones. So I think South Dakota is one of the earlier ones to put this in place, but essentially it came on, I think, through people looking at using them in offshore trust primarily. Offshore trust kind of developed a lot of these things, but one of them was the trust protector. And that can be, we'll talk about who it can be in a second. What they can do is a number of things, and the statute's listed there if you want to have a full list, but we often give them the power to amend the trust to take advantage of changes in the law, to take advantage of tax changes. In some cases, we'll allow them to change how beneficiaries benefit from the trust or grant general powers of appointment, for example, for basis planning. Otherwise, there's more, I guess, less dispositive and more, I guess, administrative things that we'll give them the power to do, such as changing situs and maybe even terminating the trust, which is less administrative, but terminating the trust, removing and replacing trustees, acting as a representative. With representatives also came the trust protector to either act as one, or to serve as one, or to otherwise, be involved and to direct how representatives can act. So something that kind of ties back to what I said in this earlier point about investment advisors is special purpose entities. So generally speaking, a fiduciary in a South Dakota trust acting as a investment advisor or distribution advisor must be an individual or an entity that is regulated by the South Dakota Division of Banking. One carve out they made was people were asking about, can I have an entity serve? Why can't I have an entity serve? It's a nice liability protection shield. It's a way to kind of centralize the management. It's almost a trust company light or a private trust company light to be able to put people in control and otherwise govern management, administration, succession, all of those things for decision makers in the trust. So what was come up with was a special purpose entity. And essentially that is an entity that is set up for a specific section there, 51A-6A-66, to serve in those roles exclusively for a trust or family of trusts. And in doing that, it won't be subject to regulation by the division, but can essentially exist as an entity and hide from a liability standard behind that shield, which is kind of nice. Last one there is one that's a little bit newer, a family advisor, and that's kind of a trust protector light, I guess I would say. It's generally designed to be, and these positions, by the way, are all optional. None of these are required in any South Dakota trust, or required to be used generally. So it's really just a matter of, which ones you like, which ones suit you and your client's needs. So a family advisor is generally one that has powers that, if held by the grantor of the trust, would not still cause estate inclusion. So removing and replacing fiduciaries, advising the trustee, and otherwise just being there to kind of have, wouldn't call it powerless roles, but power safe roles, and is often held by the grantor or other family members. And I have delegated trust there. That's what I mentioned earlier. That one is how we've ran trusts for decades before the directed trust model came in, and still today, if it makes sense, where you have a trust that's just the trustee holding power and choosing to delegate investment and or distributions as it chooses to do.
Well, thank you, Jordan. Certainly a lot of flexibility in the trust design there. And one question we get asked a lot and we deal with a lot up here in South Dakota is, I have this trust. I set it up 25 years ago. My circumstances have changed. I don't want this provision. Tax provisions have changed, various things. My children are in different spots. My grandchildren are in different spots. How does South Dakota account for that, or what flexibility do they have in modification or decanting of trust?
Sure, this is another one that I think is where South Dakota probably shines more than the rest. So I list a few out there on the slide. Again, going back a little bit, because I think it makes sense to kind of think about when and where and how this can be used. So we're talking about trusts, and I probably should put this in the slide, so I apologize for that. We're talking about trusts that are actually being administered and have their situs in South Dakota. Before we jump into how we do it, I think maybe the better question initially is, how do we get there? And so the first step for most people is, if they want to use our laws to help, make changes or otherwise do some of the things we've talked about, the first step is getting a qualified person on as a trustee. And that's, generally speaking, a South Dakota resident or a South Dakota trust company or a national company having powers in South Dakota. So one of those three typically. And once you have that, and you have the situs of the trust moved to South Dakota, you're administering the trust in South Dakota, then you can start looking at, okay, how can we go about making some of these changes? And I only point that out because it looks like you can probably just do this at any time, and it didn't lay the groundwork well. But that's step one. Step number two is, okay, how do we go about doing this? And something else I think that's worth noting is there are a lot of tax sensitive or tax sensitivities maybe in how trusts are changed. I mean, a lot of these trusts that we see move in are old. They may be GST grandfathered. Some are exempt, some are non-exempt. Might be, have a share that is one way and a share that's another way. So we're always very cautious. And I guess I also say that to say, once you get it here, the next step is, what does my trust look like? Can I do any of these things? And I would encourage anybody on the meeting today to make sure that you're looking at all of this very carefully, because I'm going to make this sound very easy today. You come in and you go to court and get a modification, it's over and done. But as a practical matter, there's a little more to it, especially on the tax side, because we really don't want to go through and blow a GST exemption or otherwise compromise some preferential tax status. Okay, so then after all that 5 minutes of being careful, here, let's go to the slide a little bit. So first way we look at is, does it make sense to use a judicial amendment or modification? And it's not first in my way of thinking about it necessarily, but first on the slide today. So judicial amendments are very common. Generally speaking, you can ask the court to do almost anything, although our laws, I would note, are changing a little bit as of a couple weeks from now. So we're having to kind of reevaluate a little bit. And what's happening on July 1st is the window and the options for which a trust can be modified by a court altered slightly to basically require a change in circumstance, which Tony mentioned, which makes a lot of sense. Historically, we've been able to go to the court for basically anything. And I think, like I said before, I think a lot of these statutes change. We look at them every year. There's something we'll talk about later called the Governor's Trust Task Force. So I think as that goes, we'll probably try to adjust that a little bit, or hopefully we can get it adjusted to make it clear about being able to go back to court for anything. But basically, the first one relates to those that you go to court for. So reformations, I'll go out of order, but reformations are generally designed to go back and replace the document as of its date of its creation. So I'll give you an example of what we did kind of recently on this. Was a trust was set up probably 5 or 6 years ago by a grantor, and the provisions were copied over many trusts, and this one just happened to be copied over 2. And essentially, this allowed the grantor to also be a beneficiary of the trust, and it was designed to be a GST exempt trust. Exemption was allocated to it. There was some protective language that said he can't be, he won't be, but in the end, it kind of said, well, upon the death of his whatever it was, mother, grandmother, somebody, a share would be created for him under the terms of the document. So what we did was went to the court, asked the court to reform that trust to basically say, excluding the grantor, these are the beneficiaries of the trust, just to make sure we had that correct. So that's what reformations is generally designed to be, a tax reformation more than anything else. Judicial amendments would generally be focused more on amendments as of today and not looking back, but making changes for circumstances not anticipated, changing of the laws, things like that would require us or allow it, basically make it beneficial for us to make changes to the terms of the trust agreement. I mentioned earlier that judicial matters are sealed in South Dakota, so we generally would file a petition for reformation or amendment. We would give notice out, which is 14 days in South Dakota, and then we would go to court and ask the court to sign the order unless somebody objects. Just as a general matter, I didn't address this in a slide either, but court matters in South Dakota are very, very simple. It's this 14-day notice, and if nobody objects, we have something every morning we call a cattle call every Tuesday morning at 11 a.m. right about now, where we send somebody over to court, we get orders signed, and if somebody objects, we set the hearing for a different day. Otherwise, the judge just goes through and signs orders as a matter of course. So every Tuesday, we end up going to the courthouse, not every Tuesday, but certainly seems like a lot of them, to run our orders through the court. Next one I'll go to, just because in the interest of time, kind of keep this moving, protector amendments. So a lot of times, old trusts aren't going to have these, but a lot of times new trusts will, at least if they were initially set up in South Dakota or another favorable jurisdiction, where the trust protector has the power to make amendments to the trust. And a lot of times those amendments don't require notice to any beneficiaries or anything like that, but simply a writing to the trustee to amend the trust for whatever the trust protector wants to do, subject to whatever powers and limitations are in the trust agreement. I mentioned there the CCA, which came out about a year and a half or so ago now. I don't know if that's familiar to anybody on the call. I guess I kind of hope it is, but that one came out right when I was about trying to do something that was right in line with that CCA. They basically told us you can't do it, and what that said was, if a beneficiary has an opportunity to object, and in that specific case, it was to the addition of a grantor tax reimbursement provision in a grantor type trust, that beneficiary, by not objecting, has made a taxable gift back to the trust. And so what came of that was, how do we go about making changes that don't require notice to or consent of beneficiaries? And a lot of times what I've mentioned above there is the protector amendment, because if you look at judicial amendments, you have notice. You look at non-judicial modification, you're signing off on the document below. That's going to be something too that requires an actual consent on their behalf. Decanting, and Tony can maybe weigh in on this, but a lot of times trustee will want court approval of a decanting if it's going to change things, especially dispositive provisions. So what we kind of landed on is, if we're going to have amendments made that change dispositive provisions that we don't want to have a beneficiary have the chance to object to, we use protector amendments. Okay, I'm skipping around badly, but decanting, I guess, was one I kind of mentioned in passing there, and that's essentially the trustee or distribution advisor, if it's directing the trustee in a directed trust, directing the trustee to transfer assets from the current trust to a second trust that generally has more favorable terms. It's a lot of these kind of seem like they may accomplish the same thing, but again, there are different rules in the tax code about decantings versus amendments, and there's also some people try to use them to cut off. Let's use an example. We had a New York trust not terribly long ago. They wanted to cut off the taxing authorities, basically at the time of the old trust. They wanted to say, look, in New York, I'm done paying tax to the state. I'm decanted to a new South Dakota trust. I don't know if that works. I'm not licensed in New York, but that was tax advice they were given, and that's what they wanted to do. And we said, okay, that's fine. You can use South Dakota trust to receive the decanted assets from the New York trust. Okay, the last one is a non-judicial modification agreement. This is probably where a lot of people default if we're not making any substantive changes to the dispositive provisions. A lot of times we use these to just change, trustees' powers and liability standards and make sure the document otherwise complies with South Dakota law. And essentially, if the grantor is living, the grantor and beneficiaries can agree in writing to amend the terms of a trust for any reason or no reason at all. If the grantor is not alive, the beneficiaries can agree on their own to amend a trust if continuance of the trust on its existing terms is not necessary to carry out a material purpose. And again, that's probably worth about a day's worth of discussion to talk about, what that looks like, what's material, what's not, who has to sign, what beneficiaries. But that's kind of a good high level of how grantors and beneficiaries can, by agreement, also change trusts. And that probably is the most common way trusts are amended in South Dakota.
Well, thank you, Jordan. A lot of ways to modify trusts, and certainly some very favorable statutes there. What are some other advantages that you've seen in South Dakota?
Sure, and I think I've gotten to some of these in passing a little bit. So I think the big one that I missed but included here was perpetual trust. South Dakota was one of the first to actually eliminate by statute its rule against perpetuities. So I think when people are first looking around and they really want to provide for a dynasty, they're looking at jurisdictions that eliminated their rule against perpetuities. There are other states that have 300-year terms, 1,000-year terms. A couple of those are perpetual, I think, too. But South Dakota is one of the few that's truly a perpetual trust state. The next one's private trust companies, and other states allow for this too. But we see a lot of private trust companies that have gotten set up here over the past couple of decades, largely because they want those companies the same protections that trustees that are professionals that are public trust companies were seeking. So we've seen a lot of clients set up their own regulated trust companies here, largely because they want to have that control over distributions or management and administration of trusts. That's another discussion that probably could last about a day, I think, on what you can and can't and should and shouldn't do with those. But I would note South Dakota does require regulated trust companies. And I don't say that as a negative thing. I think it's a positive thing because it ensures that a lot of safeguards are in place that might otherwise could cause a state inclusion for grantors or beneficiaries if certain requirements and certain, other safeguards aren't followed in states that might allow for unregulated trust companies. The third one there is the Governor's Trust Task Force. This is what I mentioned earlier, and I think this is kind of a hidden weapon, I guess I'll call it, South Dakota, mostly because we have groups that meet regularly to talk about, and it consists of trust officers, attorneys, CPAs, experts in the industry, to talk about how our laws could be better, different, changed, and to kind of address problems as they exist within the actual functioning industry. So I know that, when certain trust administration issues come up, there are people from different companies that bring those to the task force and those get cleaned up. Same with the legal side. If something doesn't work, we can't figure out what this means, we'll go back and bring it to the task force. They'll make recommendations, and generally speaking, unless there's some big objection by the governor or the banking division, I suppose, those things generally pass fairly easily because they've been pretty well vetted by the task force, which again is a group of experts that are actively trying to make the trust statutes in the industry better in South Dakota.
Well, thank you, Jordan. Could you give some, maybe just, I know we want to be mindful of time here, but just a couple of things and how you've implemented these into your practice?
Sure. let's just go through a couple of those I put up there. So SDINGs and slants. So you probably heard of some of these things, INGs or incomplete gift, non-grantor type trusts. They got really popular, I would say, in the last, well, 5 or 10 years ago, because people living in high income tax states, states with high income taxes at a state level, didn't want to have all of their income be taxable by those states. So they'd set up a trust in some other tax-free state, make that trust its own taxpayer for federal income tax purposes, and then put the assets inside that trust, which would avoid state income tax, generally speaking. Now, other states have gotten a little good about closing some of the loopholes. California was one we worked with all the time, and I think a few years ago they closed the loop in California. I know New York's come a little bit farther to kind of help define, getting fiduciaries and administration and sourced income out of New York before they can qualify for that treatment. But what's been the answer on the practicing side then for some of these is a SLANT, or a spousal lifetime access non-grantor trust. We love our acronyms. I don't know quite why, but that's what that means. So it's basically a trust for the benefit of someone's spouse and descendants possibly, but that is its own taxpayer for income tax purposes as well. So because in California, if the grantor retains a beneficial interest, that doesn't work anymore. We said, look, we can get around that by making the grantor's spouse a beneficiary of that trust. And in that case, it required the consent of an adverse party before distributions could be made to the grantor's spouse, and it usually functioned as a completed gift trust. So instead of having the assets in an ING, in my own estate, and its own taxpayer, I'd kick them out of my estate and make it its own taxpayer for the benefit of my spouse and children. And that way, you still achieved the income tax goal. And if you needed it, you also achieved the estate tax goal. With current exemptions being high, people were a little more open to that. Of course, you always have to worry about, or at least be very mindful of, should I be making gifts to irrevocable trust for the benefit of my spouse? How strong is my marriage? Is that a good idea if things fall apart? How does it all play out if things aren't as they are today? But that's kind of some of the things we've done. And I use California again because I think that's where it's primarily been used so far. We'll see if they close that one up too. Again, they seem to be kind of always on the trail to kind of generate more income out in California. So I suspect that some kind of a change may already be in the works, but we'll see how it goes. The next one, I have IDGIT and SLAT, and I guess I'm going to put those two together as number 2 and 4 there. Essentially, those are just completed gift trusts that are grantor trusts, taxable back to the grantor for income tax purposes, that are set up to be out of your estate. So a SLAT's usually that for the benefit of spouse and kids, and IDGIT's more traditionally just for the benefit of kids, descendants, whoever it may be. I'll kind of hurry through that. I know we've run out of time here. So purpose trust was also a really unique one for South Dakota, and we found all sorts of kind of fun uses for it. I think the initial one was owning private trust companies. The question is always, how do we have this thing owned? We set up a private trust company, we got it in the books, it's running, but we can't have the grantor or the patriarch, matriarch, whoever it is, own this trust company. It's got to be somebody else. Well, who wants to own this thing? All it is liability. It's not anything else. So we set up a purpose trust, which basically has no beneficiaries and a purpose that exists solely to own that trust company, in that case, as the owner of the trust company, which is perfect. We've used a similar situation for those special purpose entities. They kind of have a similar issue of ownership. But also we've even seen them to promote general charitable causes without specifically naming charities. So we'll create a purpose for promoting some certain ideal or set of ideals, and will allow a distribution advisor, trust protector to add and remove beneficiaries as it sees fit. But the trust generally exists to promote whatever it might be at that time, whatever the grantor might want. And the last one I'll mention is just foreign trusts, only because we see so many of them. And they exist for a variety of reasons. Maybe it's a distrust of local government. Maybe it's a non-U.S. person that has U.S. kids and can leave assets better in trust for them and have those assets for the benefit of the kids be out of the kids' estates and pass it to them that way. Again, that's another one that would probably take about a day to discuss. We really wanted to dive into it. But we see a whole lot of foreign trusts and a whole lot of companies that specialize in those show up in South Dakota over the past decade or so too. And that's usually, I would say primarily that's what we see is for the benefit of U.S. person, family members, and to provide for them.
All right. Well, thank you, Jordan. Great presentation and certainly highlighted a lot of the advantages of South Dakota. And at this time, we'll open it up for some Q&A here. I do see we had one question come in so far. It says if someone is considering both Delaware and South Dakota for trust situs, what is an advantage of South Dakota over Delaware? So I would say a couple things, and Jordan, feel free to chime in, but, we did cover a lot of the advantages of South Dakota. This presentation is solely on South Dakota, not really for comparison purposes of Delaware. And Jordan and I are not licensed in Delaware, so we want to be a little careful we're not speaking on that. However, that being said, there are some independent sources. I know Steve Ocean's a leading trust expert, produces every year kind of the top jurisdictions, and South Dakota is always listed, and he does list a lot of, factors that come into play as to why it is and advantages over, South Dakota versus the other states. So that would be something that I'd probably reference you to is his rankings there.
And the only ones I know, Tony, and again, I'm not licensed there, but the things that I have heard are that I don't believe the court seal is automatic there. I think it's up to the judge's discretion in Delaware. I don't know if they have a perpetual trust statute. I think it's a term of years, maybe. And I think they have a state income tax on Delaware real property that's owned by a trust, which probably isn't going to hit almost anybody on this call. But I know those are three things that I've pointed out that maybe Delaware is a little bit inferior. What I like about Delaware is I'll give you both sides. They have a lot more cases. And I think that's cut kind of both ways. They had one a few years ago that I looked at and thought, oh, this court really messed this up. But about a year later, the Supreme Court, I believe in Delaware, whatever's above the Chancery Court, came back and reversed it and got it right. So I think it's good in that you get more cases, and there is a Chancery Court there, which is designed to hear business and trust matters. But I guess I question a little bit having all those cases reported and having law on the books maybe isn't good, or a lot on the books, so to speak, but at least in the cases that maybe a little bit less advantaged for a period of time.
Thank you, Jordan. Yeah, very much appreciated. So Jordan, another question: how can a resident of another state take advantage of South Dakota Trust?
Sure, and I almost defer to you to this one, Tony, but really it's just appointing a South Dakota-based person or trust company to serve as trustee, and in that role to generally administer the trust in South Dakota. So that generally means arranging for filing of tax returns, or actually filing returns, keeping books and records in South Dakota of the trust, and otherwise, again, doing tax administration, having a place here of business is generally what it requires. And there's a statute I can send if it's of any interest, but that's usually what it looks like.
Sure. Thank you, Jordan. I would agree. And the nice part is, we talked about, certainly the assets have to be administered or inside of that trust. But the nice part is, Jordan mentioned kind of the delegated or directed trust. So you can still utilize a lot of the same advisors and have a high degree of control over the assets and still take advantage of South Dakota trust law there. Jordan, a question that came in: what are similarities kind of similar to Delaware? Question here: what is the similarity to Texas trust law, California, Nebraska?
Yeah, that's going to be a tougher one. I hear a little about Delaware because they're both good jurisdictions. I think Texas recently put in a directed trust statute, so I think that's probably a similarity. I don't believe that the statute, as far as duration, is as long. California, and I'm going very high level, I just don't know. One thing I say about California that I know Texas doesn't have, which is the state income tax, but California's got the state income tax out there as well. And I'm not, I can't give advice, I guess, in particular here, but my advice to most people is, get your trust out of California. I mean, that's usually the right answer if it's irrevocable. It's not a catch-all, but it's usually the right answer. If it's a revocable trust, for husband, whoever, wife living out in California, great. I think that makes a lot of sense if you're living there. If you're looking at setting up a dynastic type trust, or otherwise looking at planning for asset protection or otherwise, I would certainly be looking out of state, regardless of what California looks like. And was the third one Nebraska, Tony?
Yeah, Nebraska there. I'm not.
Yeah, I think Nebraska actually has a perpetual statute, but I think they're pretty far behind in the rest. and I don't know what the tax situation is like in Nebraska. You'd think I'd know. We're only 100 miles away from the border, but.
Thanks, Jordan. Appreciate
Yeah.
that. And Jordan, how do attorneys licensed in another state other than South Dakota utilize South Dakota Trust?
Sure. So this is almost a plug for myself, and I don't mean it to be, but usually it's you either get licensed in South Dakota or you have someone from South Dakota either review your draft or you have them draft it for you and you just work with the client on specific terms. I'll tell you a lot of the time from my standpoint, someone will say, hey, can you review my trust for me? It's a pretty simple process. We do it, many, many, many times a week, month, year, and it's just a simple review. Especially after the first one. Sometimes we'll like to help with the drafting of the first one because there's so many different things we can do here that someone in another state may not be able to do. But beyond that, once you got to have one and you know what we can do and not do, the reviews are usually very straightforward. And like I said, we do it frequently.
Absolutely. And that's always our recommendation as well. We have a lot of them that come into directly to our trust company, and we always have a South Dakota counsel review those as well. So thank you for that, Jordan. Another question that came in, could you elaborate a little bit on the special purpose entity and purpose trust arrangement? I'm sorry.
Oh, sure. So yeah, I guess I'm not sure what else hit on, but I think let's go to the special purpose entity first. So again, that was an entity that's exclusive purpose is to act as a distribution advisor, investment advisor, and or trust protector for a trust or family of trusts. So its role is specifically that. And I think the reason people do that is a liability protection to put a limited liability company type wrapper around the role and to separate the individual personally from that role. But in some other families, it's also because they want to have some succession built into what that role looks like. I'm going to, instead of building out my trust agreement, I'm going to build it out here. I'm going to name, ABC SPE LLC as my investment advisor and just leave it there. No power to remove and replace and bring the management and all of that over to the entity itself. Or you could keep the removal and replacement, but then otherwise build out who's got the power, when, and how that looks. So that's what we sometimes will see for those. And again, it usually ends up being one of those two reasons or both, a liability shield and or a means for succession. The special purpose trust, or the purpose trust as we sometimes call it, it would be essentially if no one wants to own the special purpose entity, to be an owner of that entity. Mostly because, again, it's kind of hard to have an owner unless it's a family member. And sometimes family members will be okay with that, but you wouldn't want a grantor necessarily to do that because of estate inclusion issues. Who'd be the only person generally who'd be willing to be the owner? Everybody else kind of doesn't want to touch that thing. So if they do, and again, that's not always the case, but if that is the case, then we sometimes set up a special purpose trust or a purpose trust to just be the owner and to exist for no other purpose than to own that entity and that's it, to just basically serve a member role. And from a district, just from a cash flow standpoint, you're often going to have a trustee fee associated with that role. So generally speaking, some of the income is generated off the trust. It pays that investment advisor, let's just say it's that, some fee, and that investment advisor, SPE, then makes payment to the trustee of the purpose trust for payment of the trustee fee. They're not generally designed to be a profit center of any kind. They're generally just designed to be to fill that role.
Thank you, Jordan. And certainly we want to be a little bit mindful of the time. I know we're approaching the hour here, and wanted to thank everybody for joining. And if there are any other follow-up questions, we would be happy to receive those emails. You can either email myself or Jordan on those. And also just a reminder that you will also receive a link to the slides and a copy of the recording as well within 24 hours of this broadcast. So thank you everyone for joining, and hope everyone has a wonderful day.